the importance of having lasting power of attorney, the importance of writing a will. And now let's assume that I die tomorrow and I haven't written a will. Where do the problems start there for everybody around me, if you like?
For everybody. Well, the funniest thing is I quite often get people coming to me and say, oh, how do I register the death and so on and so forth. I mean, it's just simple things like that, really, because they're becoming more and more difficult about who's going to register the death, who the executors are. So even getting the funeral directors involved, if they're not the executors, they want some form of confirmation from the executors that they can take instructions from the person who's instructing them. So, as I say, if you've not got anything in writing to say who the executors are, then that's when your problems start. And obviously, if you die intestate without a will, then there's nothing in writing.
Of course.
So you then have to look to the law to see what the law says, to say who is entitled to administer the estate, and indeed who is actually entitled to the assets of the estate. And that is set out, obviously, in statute.
Because that would normally be the obvious, your next of kin,
It's an order of priority.
Okay.
So if you're married, it would be your spouse. And if you have children, then possibly, depending on the value of the estate, it could be your spouse and your children, and depending on the age of the children. So, for example, if you've got an estate worth more than 250,000, then potentially your children could stand to benefit as well from the estate. So you can't just assume that everything goes to the spouse. Which is what a lot of people do assume.
Of course.
I'm not going to be making a will, because if anything happens to me, it'll all go to the wife, it'll go to the husband.
Both die at the same time, and you've got a big problem. And that can happen. Well, that can happen. Plane crash, car crash, you're often together. It can happen, and people just ignore that fact. They just think, well, is that going to happen? Of course it does, Well,
it's funny, in that sort of scenario, usually what will happen is they will look to who was the eldest, and the eldest is always deemed to have predeceased the youngest.
Indeed,
So, and again, in that scenario, if everything then goes to the youngest, you've then got an estate that's all in the youngest hands, and not necessarily going to go where you wanted it to go.
Indeed.
So again, intestacy rules would then step in, and you may find it's all going to partner's estate, and your estate ends up with nothing. So,
absolutely. So again, if you've been remarried, you really need to seriously think about that consequence, don't you?
But I mean, it's a reality, and it can happen. But so you look towards the intestacy rules. The intestacy rules say who can actually take out this grant. It's a slightly different title. It's the same thing really as a grant of probate, where you have a will, but it's a grant of administration, a letters of administration, which again is a very grand title. But effectively, it is the court's recognition of your validity, if you like, to deal with the estate. So, so as I say, if you're married, it would be your spouse. If you're not married but you have children, it can be your children. And it goes all the way down to brothers and sisters, half brothers and sisters, and so on and so forth. And incidentally, even if you have a will, if there is a problem with the executors in the will, so for instance, if they've all died, you would also go down the same route. The intestacy rules would then dictate who's going to take out the grant. Potentially. It depends who's named as the beneficiaries in the will, because you could end up with partial intestacy. So again, you may end up having to apply the same rules, even if there is a will, depending on whether there's still executors there. So you would look towards the intestacy rules. Obviously, as I say, that the person entitled would then make an application to the court. The court would then give you this grant of letters of administration, and that grant would need to then be produced to the various asset holders so that they recognise you as the person who can give a valid receipt for the money, for instance. And again, it can cause problems if you have what's called a minority interest. So if you have children who are under the age of 18 years, and actually I've got one that is similar to this at the moment. We've got one elder child who is 18, and we've got two younger children who are 14 and 7. And unfortunately, it does mean that you do need more than one administrator to manage the estate, because you've then got two minors who are going to not inherit the asset straight away, but have money invested for them until they attain the age of 18 years. So again, you have this additional involvement where you don't have a will where the law says, well, you can't inherit until you're 18, so we have to put it on statutory trust for you. You will then inherit at 18. So again, to some extent, it takes your choice away. Whereas in a will, you can say, well, they can have it at 60. It takes the choice away. They have to wait until they're 18. Or you may decide, well, if they're only 18, I'd rather them have it at 25.
Right, okay.
Again, you can specify.
Yeah, of course, yeah. That would be a very logical thing to do anyway in most cases, wouldn't it? Yeah.
Whereas the intestacy rules say, well, no, 18, they would become entitled to that.
Wow. See, that in itself is a huge issue. I mean, unless you've got an incredibly mature child that you've got every belief that they would not go off the rails with. An awful lot of us, I'm glad I wasn't given a large sum of money when I was 18 years of age, because believe me,
you think you're grown up at the time, don't you? When you look back.
that money would have been wasted. Yeah, I'm now clamouring for George Best's famous sentence, about what he wasted his money on, and the rest went on women and booze or something. Whatever his joke was, it was a good one. But yeah, at 18 years of age, of course, I would have run out and bought umpteen motorbikes, and there would have been it.
And again, in a scenario where you've perhaps got a second marriage, as you say, children from a first marriage, the relationship there might not be great.
Absolutely.
And it could cause all sorts of potential.
Of course it can do.
Where you've got the new wife who's now dealing with the estate for younger children.
Correct. Yeah. It's just complex. Anyway, even if everything is hunky-dory and everybody is happy and everybody is still looking after your best interest after you've passed away, it still leaves conflict. Somebody somewhere could say, no, I don't think that's what he or she wanted, even if it was, it was written down, so no, it's got to be written down, doesn't it? It's as simple as that, and then there is no dispute at all. In an ideal world, you'd actually be open enough to be able to discuss what you've written in your will with every beneficiary that's going to be there, but that's not. It's not very practical, is it? No, it doesn't.
I think if you're in a very straightforward situation where you've just got mum and dad and two kids, then it can all be very open. But as you say, you get a bit more complex family arrangements or second marriages. It's not necessarily as open then as what you'd want, but. Even the problem is people bury their heads in the sand, I think, as well.
Of course they do,
and they don't want to face it.
No,
I can't think about it. I'd rather just, whatever's going to happen is going to happen. But as you see,
and I won't be here to pick up the pieces, because that's exactly what you are doing. But this is why I mentioned before that you're at the nerve end of this. You've seen this on many occasions. You've seen the heartache that can be left and the problems, financial and emotional problems of somebody if they'd just written down what they wanted, then we wouldn't all be sitting in this room and arguing about it now.
And I think the difficulty is as well, a lot of people don't realise that if you're dealing with the intestacy rules, then people who have predeceased you, even though they're predeceased, they won't get the entitlement to the estate. But if you've left children, then those children will be entitled to their
Of course they would.
share.
Of course they would.
And that might not necessarily be what you intended either. You might just assume, well, your brother and sister died, their kids won't get anything. But unfortunately, that's not the case, because you then have to look down the line. Well, if they left children, or if they were,
that's right. They would have been entitled had their parents
share between them. So that's a lot of people don't realise that as well. So we've had situations where we've, again, going back to genealogists, we've had to instruct genealogists because we've had to locate distant cousins who are situated all over the globe to try and find these people to make sure they get their 116th share or whatever. He'd actually got that.
I can imagine.
Dividing these shares. And the expense that it cost the estate was just unbelievable.
Absolutely amazing.
And we ended up with this report from the genealogist, which covered at least 2 desks, because it just went on and on and on.
Unbelievable.
And it was just, and I'm sure the chap who did it never intended.
Of course he didn't. There's no way you could ever say that, could you? You'd have to have a very, very warped sense of humour in your moments of demise to turn around and say, do you know what? I hope that I'm going to leave an awful lot of problems, and genealogists and solicitors are the only people who are going to benefit from it. Nobody wants to put their family through that problem, do they?
In fact, that chap in himself had done a will. This was the thing about
it.
He'd actually done a will. But he'd left everything to his brother, and unfortunately, brother had
predeceased him. Well, then the will is useless. The will has to be updated, doesn't it?
Even if you do a will, you could still end up dealing with the
So
it's another important thing where you need to make sure you keep it reviewed. But that chap himself had actually done a will, and we still ended up with these.
But it was a predeceased will, so therefore you could argue and say, well, his will was no use, was it? So yes, he had written a will, but in all honesty, the beneficiary had died before, so therefore, to be honest, that's.
What should have happened is he would have come back. When
Absolutely, absolutely, and start again. Yeah. So therefore, right, okay. We're going to have a little bit of a break now. We're going to listen to a band that you just went to see very recently.
I did, Manic Street Preachers.
Yeah.
Yeah.
And were they good?
Very good. Yeah.
And this
very
track that you've chosen, Design for Life, was a particular.
The highlight of the evening. Rise
Was
Me
it?
My Student Days.
Oh, for goodness sake! Really?
Yeah.
Oh, for goodness sake! We haven't gone back to student days. Right, we'll be back with Vicky in a minute or two, and I think we'll talk about that very subject that we've just finished on there, disputed wills. What you can do if you feel that you do have some entitlement. Can we do that?
Yeah.
Yeah, we're doing arguments about